Hello aspirants, welcome back to Where IAS. In our discussion on Indian polity, we were studying about fundamental rights. So before we study about the fundamental rights, I said these are the topics to be studied under fundamental rights. That is, we must know the meaning of right. Right is nothing but it is a claim or a benefit we can say. This claim is against state. So this is the meaning of right. Then what is the meaning of privilege then? Privilege we can simply call it as a special right. And this privilege is given to only few citizens, only for few people. Take for example for governor or president, they enjoy certain special rights because of their office, right? So this is the meaning of privilege and this is the difference between privilege and right. That is, right is enjoyed by all the citizens whereas privilege is a special right which is enjoyed by only few citizens. And then we must know the difference between the constitutional rights and the statutory rights. So here the constitutional rights have the backing of constitution itself, whereas the statutory rights has the backing of a statute or a simple law. Here again in the constitutional rights we have what is called as the fundamental rights and other rights. So fundamental rights are nothing but in the constitutional rights, the rights which we see in the part 3 of our constitution is called as fundamental rights, whereas the other rights seen other than the part 3 are called as the other constitutional rights. So here the fundamental rights were taken from America's Bill of Rights. And what is the importance of fundamental rights? If we see the placement of fundamental rights, that is, it is placed in the part 3 of constitution. That is very soon after the defining our territories, that is in part 1 and part 2, we see the placement of fundamental rights in part 3. So this itself, the placement of fundamental rights in constitution, that is in part 3 of constitution itself speaks about the significance of fundamental rights. And in characteristics of fundamental rights, we studied the various characteristics like fundamental rights are not absolute. That is, while enjoying the fundamental rights, we also have certain restrictions to be remembered while enjoying the fundamental rights. So fundamental rights are not absolute, and also fundamental rights are justiciable. That is, we can go to the courts for the enforcement of fundamental rights when it is violated. So the fundamental rights are called as justiciable rights. And also we studied that fundamental rights can be suspended. So when it can be suspended and all that we had studied in our previous video lectures. And we started with the classification of fundamental rights. Earlier I said there were 7 fundamental rights, but one fundamental rights was removed and therefore we have at present 6 fundamental rights. So the right which was removed is right to property, and it was removed through 44th Constitutional Amendment Act of 1978. So at present, the present status is we have 6 fundamental rights. So they are, the first is right to equality, second we have is right to freedom, third we have right against exploitation, fourth we have religious freedom, and fifth we have the cultural and educational rights, and at last we have right to constitutional remedies. That is, for the violation of fundamental rights, we go to courts and seek remedies, right? This itself is made as a right. So this itself is a fundamental right, the right to constitutional remedies, the 6th fundamental right. So already we had studied these 4 fundamental rights, that is right to equality from articles 14 to 18. Next we have right to freedom, articles 19 to 22, right against exploitation, article 23 to 24, and the next one is right to freedom of religion, that is from articles 25 to 28. We had already covered all these 4 rights in detail. Now before starting the next fundamental right, we shall revise right to freedom of religion. Right to freedom of religion, I said it is from articles 25 to 28. So in short we can say article 25 is guaranteeing, that is, it is guaranteeing the right to conscience, profess, practice and propagate religion, whereas article 26 is providing rights for religious denominations. That is, religious denominations has the right to establish its religious institutions, and also it has the right to acquire property, both movable and immovable property. So this is about article 26. Next we have article 27. Article 27 simply says no taxation on the religious activities. Article 28, it says how the religious instructions can be provided in various educational institutions. So this is about the article 28, and this completes the right to freedom on religion. We had discussed each article in detail in our previous video lectures. Now let's start with the next fundamental right, that is we have cultural and educational rights. and this includes articles 29 and 30. We shall study these articles in detail. First we have is article 29. Article 29 has got two classes. Even article 30 has also got two clauses. So the first clause in article 29, that is article 29 clause 1, is providing rights for all citizens or the group of citizens. That is, it is providing rights to what? It is providing rights to conserve what? That is, to conserve any distinct language, culture and script. India being a diverse country, there are various various groups which is having their own distinct language, culture, script, right? So the protection of the same is very essential. So Article 29A is providing, clause 1 is providing the right to conserve these distinct language, culture and script. That is, it is providing for three things. That is, to conserve the distinct language, culture and script. Whereas Article 29.2 is telling no discrimination shall be made, where, that is, while seeking admissions into the educational institutions. That is, while seeking admissions into the educational institutions, no discrimination shall be made on what grounds? That is, on the basis of religion, caste, language and race, you can't discriminate. So this is the Article 29 clause 2 is providing for. And also it is to be noted here that in educational institutions, that too the educational institutions owned and aided by state. So in these educational institutions, while seeking admission, there shall be no discrimination made on the basis of religion, caste, language and race. This is about Article 29. Now let's study about Article 30. Article 30 also is providing for two clauses. So here Article 30 clause 1 is providing rights to whom? That is, it is providing rights to minorities, whether religious or linguistic minorities. For these minorities, the religious and linguistic minorities, it is providing rights to what? That is, to establish and administer the educational institutions. So Article 30 clause 1 is mainly providing rights to minorities, that is for religious or linguistic minorities. Whereas Article 29, I said, it is providing rights to all citizens and group or the group of citizens. That is the main difference between Article 29 and Article 30. So Article 20 is providing for all citizens, whether minorities or majority, whereas Article 30 is speaking in particular about the minorities. That is, Article 30 clause 1 is providing rights to minorities, whether the religious or the linguistic minorities, to establish and administer the educational institutions. So this is about Article 30 clause 1. Whereas Article 30 clause 1A was inserted through the 44th Constitutional Amendment Act of 1978. What it says is, if the government acquires any property of the minority institutions, then the government has to provide the adequate compensation for these minority institutions. So if the government wants to build any infrastructure and the need of it, maybe the government has to acquire the property of that minority institutions, then yes, government can acquire. At the same time, government has to provide the adequate compensation for this minority institutions. So this is about Article 30 Clause 1, Subclause A, which was inserted through the 44th Constitutional Amendment Act of 1978. Next we have is Article 30, Clause 2. Article 30, Clause 2 is also saying that there shall be no discrimination. For what? That is, while the state is granting any aid to the minority educational institutions, the state shall not make any discrimination, should not make any discrimination. That is what is Article 30 clause 2 is telling about. So if we see the main differences between Article 29 and Article 30, Article 29 is providing rights for all citizens, whereas Article 30 is giving rights for minorities, that is whether religious or the linguistic minorities. So, and also Article 29 clause 1, I said it is providing rights to conserve distinct three things, that is language, culture and script, whereas Article 30 is providing rights to these minorities, whether religious or linguistic minorities, to establish and administer the educational institutions. So the main difference first is to all citizens, that is Article 29, whereas Article 30 is speaking about minorities only. And also Article 29 clause 2, I said it is telling no discrimination while seeking admissions into educational institutions that is owned by that is state owned or aided educational institutions on the basis of religion, caste, language, race. So on these grounds you should not make any discrimination. That is Article 29 clause 2. Whereas Article 30 clause 2 is also speaking about discrimination, but it is telling no discrimination that shall be made by state while granting aid to the minority educational institutions. So this is about Article 30 clause 2. And this completes the cultural and educational rights. And also here it is to be noted that cultural and educational rights, it is this is the name it is providing, that it is mainly speaking about the cultural and education, but this rights is more of giving rights to the minority rights, right? It is speaking more about minorities. Yes, the cultural and educational rights, it is providing rights to the minorities, and this word minorities is nowhere defined by constitution. Constitution is simply telling, it is recognizing, I can say, two types of minorities. One is religious minorities and the linguistic minorities, that is we see in article 30. Okay, the definition of minorities is nowhere provided in constitution, whereas Supreme Court in one of its judgment has provided the definition of minorities. It is simply based on the number of people present. So that is the meaning of minorities. Now it is to be remembered that minorities, the constitution is recognizing only two types of minorities. One is based on religion and one more based on language. And this completes the cultural and educational rights, that is from articles 29 to 30. So the next fundamental right we have is right to constitutional remedies, that is article 32. We shall study about that in our later video lectures. For more videos, keep watching VAR IAS, and also please subscribe, share VAR IAS. Thank you.